We are back live, another intellectual property infringement breakdown. And today is actually a pretty interesting one. It's different, it's in the line of trademarks. I actually try to bring you guys these different cases, different scenarios. And 2 or 3 days before Sunday, I go through the list. You'll be surprised of how many intellectual property lawsuits that are filed just really on a daily basis here in the US, whether it's trademarks, copyrights, patents related, whatever the case may be. And man, I go through these things and I try to kind of bring different scenarios, different companies, different situations. I really do a lot of work in terms of trying to prepare for this, where I'm reading the different complaints and seeing if something is bringing something new to the table that we haven't discussed before. So as I was going through, trying to select one for today, I came across the Nikes and I'm like, okay, yeah, we talked about Nike already suing the little guy. And then I, maybe came across the Chanel and like, okay, yeah, we talked about Chanel already suing the bootlegger. And maybe Christian Dior. Yeah, we talked about kind of Christian Dior suing somebody who's trying to sell knockoffs. Then I actually came past a Playboy lawsuit, and it was actually interesting. And as I was going through it, I'm like, oh yeah, this is something different. But then it's like, man, it started to look too much like a Playboy magazine. And I'm trying to be more family friend, a more family oriented show, a family friendly show, so that you guys can learn this intellectual property because it is valuable. So although I thought that Playboy one was pretty good, and it just the pictures, the visuals, it became a little bit kind of 2X rated to kind of show in my liking. And I didn't really feel like going through and redacting because it was that many photos that I didn't want to go through and redact all those X-rated photos in that complaint. So we set aside the Playboy one and actually came across this Knickerbocker, which, man, it's crazy. They say what is over 30 million small U.S. businesses, which is a U.S. business, a small U.S. business is one that's 500 employees or less. And it's, 33 million small U.S. businesses or small businesses in the U.S. that I was looking at employ approximately almost 62 million people, which is half of the workforce. And man, I thought it was different because Knickerbocker, which I'll kind of bring them up here and show you guys, this Knickerbocker, they make bed frames. And as you see here in the right-hand corner, they've been around since 1919. So, over 100 years, 105 years. And I'm like, man, this is a small business, but hey, anytime you're around for 105-year family business, you're doing something right. So, and the fact that not only I'm talking about a small business, Knickerbocker, but they're actually suing a big guy for trademark infringement, which I said before, it's a change of pace because typically we have the Nikes and the Dior's and the Chanel's and these bigger companies suing a little guy, but it's kind of tough to say someone who's been around for 100 years is a little guy. But Knickerbocker, they are less than 50 employees, I think. They're suing Wal-Mart for trademark infringement. So I'm like, okay, this seems pretty interesting to go through and kind of talk about and see what lessons we can learn from it. So I'm like, okay, let's do it. So I actually, and again, this company, Knickerbocker, they sell bed frames. And I actually, this is several years ago now, was putting together a bed frame for, someone I know who, need help putting together her bed frame. And I wonder whether or not it was a Knickerbocker bed frame. I think she got it off of like Amazon or whatever the case may be. And hey, if it was a Knickerbocker bed frame, I could tell you one thing: that thing was pretty sturdy, from personal experience. But let's get off into it. We are going to take a look at the lawsuit really quickly, and I'm not going to keep you guys too long today. So we're going to take a look at the lawsuit, and again, what's different from this lawsuit compared to other lawsuits is typically we'll read a complaint and then that's pretty much it. And I would imagine that a lot of these times when, say, the Nike is suing somebody else and they kind of file a lawsuit in federal court, at some point, the two sides are going to come to the table and it's going to end in a settlement. Most lawsuits end in a settlement. They rarely go to trial where you have a jury or a judge deciding on the matter. Typically, they get settled before that point. But in this case, again, another change of pace is we have the little guy suing the big guy, but then the big guy in Wal-Mart, they actually filed an answer. So it wasn't one of these things where, at least at the beginning, both sides coming together and they are trying to negotiate a settlement, at least at the beginning. It seems like Wal-Mart, again, being a big guy, they actually filed an answer to the complaint of the little guy. So we'll get a chance to take a look at Wal-Mart's complaint. And I'll tell you what, They denied everything. We're not committing trademark infringement. We're not committing trademark dilution. We're not committing unfair trade practices. They pretty much denied everything. So we'll take a look at that lawsuit as well. And let me kind of pull up here. Let me try to pull up here the lawsuit. Let's see here. And we'll get off into it. So this is the lawsuit from Knickerbocker. And Knickerbocker, as you can tell, they actually have their intellectual property owned by Finger Lakes Intellectual Property, which some companies do it. And I had the owner of Big B Coffee, I have his book out, Mike McFall. I had him on. I interviewed him several months back in Big B Coffee, which again, it's not as big as Starbucks, but they're generating hundreds of millions of dollars a year in revenue. And he said they're kind of structured like this, where they have all their intellectual property in a separate company from the operating company. So Big B Coffee, as the name may suggest, they make coffee. So they have an operation company that sells the coffee. Then they have a separate company which owns all the IP, all the Big B trademarks, all the Big B copyright books, things like that. And there are two separate entities, and the operation company pays the IP, that company that owns the IP, a royalty payment to be able to use the IP. And it actually gives much more authenticity or credibility to the actual IP, the value of the IP. So it seems like, just kind of looking at the way that kind of the lawsuit reads, where it's Finger Lakes Intellectual Property, it seems like they are Knickerbocker has a similar setup where all the IP that Knickerbocker owns. And I mean, I did some research. They actually, we're not going to talk about them today, but they own patents, they own trademarks, they own copyrights. It seems like all that intellectual property that Knickerbocker owns is, owned by Finger Lakes Intellectual Property. So that's cool. And then you see here the defendant, which again is different. Wal-Mart is on the defendant. They're not on the offensive, but in this case, they are on the defensive. So again, pretty cool. And if you come in, just check in, let us know your name, and to the extent that you have any comments on this lawsuit. Knickerbocker, that makes bed frames and beds and things like that, is suing Wal-Mart for essentially using their trademark without permission, thus allegedly committing trademark infringement. So let's move on here. Plaintiff, Finger Lakes Intellectual Property, which is a Jersey company, and Wal-Mart, which I'm pretty sure a lot of you don't know. I'm pretty sure you all know that at least it's a Delaware corporation, but their main corporate office is in Arizona. So we typically skip the jurisdiction and venue and try to get to the juicy stuff, which is the facts common to all causes of action. So plaintiff is a leading manufacturer of bed frames and bedding support systems, a family business originated over 100 years ago and now in its fourth generation in the United States. Man, that's huge. And I try to get you guys to think about this intellectual property. I was on kind of scrolling through in Instagram earlier today, and it was a page. They had hundreds of thousands of followers on Instagram, and they were saying, okay, name essentially one thing that Black people need to kind of help out going forward. And I commented intellectual property. Again, that's going to be the value of, especially in 2024. Here in the U.S., we sell intellectual property. This is not like a big manufacturing country like it once was. When you think of your favorite movies, your favorite TV shows, Disney parks, things like that, that's all intellectual property, copyrights. When you think of your favorite big tech company, whether it's the Microsofts or the Androids or the Apple, that's all patents, that's all technology. When you think of your big brands, the Nikes, the Starbucks, the Chick-fil-A, those all are trademarks. So we sell intellectual property. That's what the U.S. sells to the rest of the world. And to be honest, the rest of the world is trying to get in on the game. And that's why they are trying to file for intellectual property protection here in the U.S. so that you can actually buy their products as well. So again, we're seeing here, what's going on, Brandon? You see Brandon checking in. What's going on, B? Good to see you. We're again just talking about getting off into the complaint here between Knickerbocker, which is a bedding company out in Jersey, suing a big guy, which is, again, this is a change of pace, and Wal-Mart. And again, item 4, paragraph 4 of the complaint, that's talking about how they're in their fourth generation family business. So I think, again, when you're talking about intellectual property, whether it's patents, copyrights, trademarks, you're selling a service, you're selling a product, that's something that you can pass down generation after generation. And hopefully it's, your brand is associated with quality, great customer service. And as we can see here, Knickerbocker, the bedding company, they're in their fourth generation, which I think is amazing. And again, a big part of that is their intellectual property, as they have trademarks, they have patents and things of that sort, which kind of helps out. So paragraph 5 here, plaintiff or plaintiff's related company, a Knickerbocker, I'll just say going forward, is the plaintiff, has used the mark Knickerbocker since at least 1919 to distinguish its goods, namely trundle beds, folding beds, and platform beds, bed support system, namely bed frames, cross members, and related non-metal and metal hardware units, bolts, brackets, so forth and so on. Through its extensive sales and advertising, Knickerbocker has developed extensive goodwill throughout the U.S. with respect to the mark Knickerbocker. Plaintiff or Knickerbocker owns a U.S. registration for the term Knickerbocker, which it gives the registration number. That's good. And Knickerbocker U.S. trademark registration for Knickerbocker is valid and subsisting. So essentially, it's concurrent. They're actually using it. A plaintiff Knickerbocker bed frames and bedding support systems are promoted and sold under the mark Knickerbocker to many of the country's finest department stores and furniture outlets and sleep shops. Knickerbocker bed frames and bedding support systems are also promoted and sold on various websites. So what is this telling me as an IP attorney? They're saying not only are they themselves selling this stuff on their websites, but they're actually wholesaling it. You may find it in Target. You may find it on Amazon. You may find it on in different companies' stores where they're giving actual genuine licenses to be able to sell their actual product. And what they're going to continue to allege in this lawsuit is Walmart is not one of those people. Say, yeah, we do give out licenses to sell our products, our bed frames, our cross members, our mattresses, but Walmart is not one of those people. That's what we're going to essentially get to in this complaint here. So let's go to 10 here, paragraph 10. As a result of its long-standing and widespread commercial use, the Knickerbocker trademark and trade name has garnered substantial recognition and goodwill through the U.S. Paragraph 11, plaintiff is not a supplier to defendant. So they're saying, hey, we supply to a lot of people our bed frames so they can sell. Walmart is not one of them. Nevertheless, Walmart is advertising and marketing and offering for sale bed frames utilizing our trademark and trade name in order to drive customers to their website at walmart.com and specifically to walmart.com. So we'll get off into here in just a minute. We'll take a look at walmart.com, and I want you guys to let me know to the extent that you're watching this live in the comment section. But if you're catching this after the fact, please let me know in the comment section what you think about this. Paragraph 12, the heading of the webpage at walmart.com is Knickerbocker bed frame. Man, let's take a look at this website. And again, we're going to go to Amazon's website. Walmart, I'm sorry. We're going to go to Walmart's website. And the thing I like about trademarks is a little, they're more straightforward. So again, we saw this. Let me bring it back on myself really quickly. We saw this a couple weeks ago when Team USA or the Olympic Committee sued Logan Paul and his company Prime Hydration for essentially using their trademark on Team USA for the sale and promotion of their products. So I'm not sure if you guys remember that. We did a live on that. I think we did a live on that a couple weeks ago when the Olympics was opening, where the Olympic Committee, who owns the trademark, all the trademarks, Team USA's and Going for Gold and all that, they actually sued Logan Paul and his company Prime Hydration for trademark infringement because they were using the Team USA, which is one of the many trademarks that they were saying were infringing, on their website to try to sell their essentially fitness drink. And we have a similar case. So you guys have to let me know what you think as I bring up the website here. Again, trademark law is pretty straightforward. This is Walmart.com. You see it up top. You see the logo Walmart. And what do you see here? Knickerbocker bed frame. It seems like they're selling one of them for $150 just a frame. And it seems like they're having a wooden frame. Man, that's for double the price, $305. You guys have to let me know. Have you bought a Knickerbocker frame? They've been around for 105 years. So I'm assuming that they're doing something right as it relates to the quality. Let me know in the comment section or in the chat. Have you guys ever bought or slept on a Knickerbocker bed frame or bed pad? It seems like, as I'm looking at it as an IP attorney, it seems like it's kind of cut and dry. You have Walmart.com, and we already saw from the complaint that Knickerbocker is saying, look, we haven't given them a license or supplied our bed frame to them. So they're actually committing trademark infringement. And to the extent that there are any patents on these bed frames, they may also be committing patent infringement, which they don't get off into. So again, Knickerbocker bed frame seems like $335. I don't see any in a title here, but specifically when you type for again, it's two of them that again you see king size Knickerbocker Deluxe. And we again, Knickerbocker, as we just saw in the complaint, is a federally registered trademark term. So it's not looking good for Walmart at this point. Let's get back to the complaint and essentially see what the complaint has to say. That's why I like trademarks, because trademarks are a lot more straightforward. I know with the patent stuff, a lot of times it's up for interpretation. But again, if you're using our trademark term, that's trademark infringement. That's why I like trademark law so much, because it's pretty straightforward. It's less of a subjective standard. You have some subjectivity up in there, but for the most part, it has a high level of objectivity. If you look at the mark, in this case, we just saw on Walmart.com website, they're actually using the term Knickerbocker, which doesn't look good. So paragraph 13, a web page, which we looked at one of the web pages, followed by at least 25 more web pages, starting with Walmart.com. It has Knickerbocker in the URL. All of this gives the false impression that these products are sponsored and fulfilled by Walmart, or that the defendant is an authorized dealer of Knickerbocker bed frames. And again, Knickerbocker is saying, we don't mess with Walmart. We don't mess with them. That's not who we are, one of our suppliers. Yet they're selling our bed frames online, at least, which is not a good thing. So look, it says defendant's action Walmarts were brought to the attention of Walmart's legal counsel in Arizona. It seems like the legal counsel refused to address the issues brought up by Knickerbocker's counsel correspondence, and responded that Knickerbocker should submit any claim to brand portal. Man, look it. Hey, how just pretty much gutter is that, where you're trying to, as we see typically, you send a cease and desist letter, and you got your counsel is calling up pretty much opposing counsel that you're saying is infringing their trademark, and the opposing counsel like, yeah, just submit your complaint to our portal. You're like, what? We're not doing that. This is a trademark infringement case. I need to communicate with the attorney. Forget this portal where it's gonna go back to the queue, and who knows when is somebody going to get back to me. That's when you know Walmart, hey, they the big guy on the block. When your attorney call up the other attorney and they tell the attorney, hey, submit your complaint to the portal. That's crazy. That will never happen with another company. Like, in other words, if Walmart was to give a complaint for trademark infringement to another company, and the other company told Walmart to submit their stuff to their portal, Walmart wouldn't be going for that. So that's very surprising that Walmart, what they say in a paragraph, what paragraph was that? 15 here. Walmart legal department refused to address the issues brought up by Knickerbocker, and responded that Knickerbocker should submit any claim to the portal. We telling you committing trademark infringement, and you say submit it to the portal? That's crazy. Knickerbocker claim was submitted through the claim portal, and then they did it. I told, just going back to the queue, y'all, you have to let me know, would you have done it? Look at paragraph 16. That's how, that's crazy. That's how you can tell you the big guy on the block. Walmart is telling Knickerbocker to submit their stuff to the portal. And what does paragraph 16 say? The claim was submitted through the claim portal as requested. Hey, that's how you know you're the big man on the block. Man, submit your stuff to the portal. And you actually submit it to the portal. I don't know. I don't want to say nothing bad about this attorney, but I'm telling Walmart attorney, you need to deal with me. I'm not submitting nothing to no portal where it's going to go to the queue, and y'all may never see this thing. Make sure the mic don't. You need to deal with me, whether it's through email, send me a written correspondence via mail, or let's talk over the phone. I'm not giving something to the portal. That's crazy. That's how you know Walmart is the big man on the block. And I guess sometimes the big man got to get taken down to learn one way or the hard way. Let's go to 17 here. Walmart representative from Walmart Trust and Safety responded that a Walmart search they throwing them around. They giving them the run around. You call the legal department to handle this trademark infringement action that you're saying, and next thing you know, you're talking to Trust and Safety. Trust and Safety, Walmart's Trust and Safety responded that Walmart search URL was provided, and that to work the claim properly, plaintiff claim must be resubmitted using a You talk about somebody giving them the okie doke. Yeah, Walmart knew what it was doing with this one. I can't wait to see this Walmart answer that we're gonna read after this. So it seems like Knickerbocker explained in a response that it is the use of the Walmart search URL which must cease, and that Walmart is using plaintiff trade name and trademark in its search URL. Look at this, pretty much what they're saying. 17 is saying Walmart representative from the trust and safety. I'm not sure why trust and safety is on the line, but some seem like they got a hold of trust and safety, and they responded that Walmart search URL was provided, and that to work to claim property, Knickerbocker claim must be resubmitted using a valid Walmart.com URL. And Knickerbocker is like, hey, y'all need to take this URL down. This is not, you're right. This is not a valid URL. Y'all need to take it down. And Walmart is saying, yeah, y'all, you need to resubmit your claim with a valid URL. And Walmart is like, that's what we're talking about. Y'all need to take the URL down because it's not valid. We don't mess with y'all. That's pretty much what's going on here. This is crazy. So let's go to 18. Y'all got me working up a sweat here. So plaintiff explained, Knickerbocker explained in a response that it is the use of the Walmart search URL which must cease. Y'all need to actually take down the URL. That's what we're saying. And Walmart is using the trade name and trademarks in its search URL. That's essentially against federal and state law. So by using it, okay, so Walmart's trust and safety representative merely reiterated in response that she needed the item. Man, that's crazy. They're giving these guys a runaround. So after much back and forth, I told you they're giving them the runaround. After much back and forth, paragraph 19, including detailed explanation by Knickerbocker's counsel and providing a sample of the URL from 1,000 or more products being promoted under Knickerbocker. So they was promoting 1,000 products under Knickerbocker bed frame. I just did a video of Isaac Hayes and the Hayes family going after Trump for 134 illegal counts of trademark infringement or copyright infringement for the song "Hold On, I'm Coming." It seems like they have at least 1,000 counts of illegally using the trademark Knickerbocker. So a different representative, man, it's crazy. So this time a different representative from the trust and safety sent a request for information about the product shown in the URL, provided such as pictures of, and they giving these guys a run around. Then paragraph 20 here, a response was sent to this inquiry, but nothing was heard from the defendant, nor did the defendant take any action in the face of over. So look at this, essentially what's going on. We all see for the C students in the back. They call up the council. Knickerbocker call up Walmart council. Man, y'all commit trademark infringement. What's good? Y'all need to take this stuff down. The counsel for Walmart like, hey, yeah, just submit it to the portal, and we'll figure this out. So then Knickerbocker, they actually sent it to the portal. So now somebody from the trust and safety is like, this is an invalid URL. Y'all need to resubmit it. So they like, no, we need to. This is what we're talking about. Yeah, the URL that y'all using is invalid. Y'all need to take it down. Cease from using operations. So for whatever reason, Knickerbocker counsels resubmitted. Then they get a different person from the trust and safety at Walmart, and they pretty much hit a dead end. So that's essentially what's going on so far. Talk about the runaround. A response, paragraph 20 here, a response was sent to this inquiry, but nothing was heard from defendant, nor did defendant take any action in the face of the overwhelming evidence. They said they were using this thing on 1,000 what they say, 1,000 or more products being promoted under Knickerbocker. That's crazy. Then, essentially, Knickerbocker got fed up. Like, okay, defendant's use of the mark is confusingly similar to plaintiff mark. No stuff is actually the same. To trade on plaintiff goodwill, to deceive customers, and to cause damage to plaintiff reputation, which, as we talked about, they have got that reputation over 105 years. And at this point, they hit him with the lawsuit. So federal trademark infringement, count one. We're just gonna read count one. We're gonna read the answer, because again, we typically don't get the answers, but I would imagine that Walmart, the big dogs on the block, is gonna definitely give an answer. So we'll take a look at that one and see what Walmart is saying. So let's start at paragraph 23 here. The conduct of Walmart as alleged herein constitutes infringement of Knickerbocker trademark. Walmart unauthorized activities and infringements are likely to cause consumer confusion. Yep. I'll probably agree with that so far as kind of given what we're seeing. Walmart has full knowledge of plaintiff's exclusive and long-established propriety rights into the trademark, but continues to proceed in complete disregard thereof. They're talking about the damage to goodwill is willful, malicious. Anytime you see willful, that's 3 times the damages that Knickerbocker is going to be asking for, in addition to an injunctive release to keep Walmart from actually using the term. And again, essentially talking about a likelihood of essentially the likelihood of confusion. So that's pretty much it. They have some other counts, but that's pretty much it. So now, like I said before, typically you have the big guy suing the little guy, and early on in the process, you will get, okay, let's come to the table and work out a settlement. But the first term we have is the little guy suing the big guy, and it seems like it's no, okay, let's get on the phone and talk out a settlement. Walmart is they provided an answer, which we're going to pick up right here. So let me stop sharing my screen really quickly. What you guys think so far? Let's see here. Share. We're going to go to the entire screen right here. We're going to go to this one. We're going to share this one. There we go, right here. So what I have here to the right is Walmart's reply. And we're going to compare it with the complaint, which is on the left. So let's start here on the right. Walmart lacks knowledge or info. So again, let's look at the top. Seems like they got some big dogs. Some guys in West Virginia, Massachusetts, and New York. Seems like that's their council. Oric, Harrington, and Sutcliffe. Finger Lakes intellectual property, that's essentially Knickerbocker, and then you have Walmart. And as we talk about, this is Walmart's answer to the complaint and demand for jury trial. So defendants Walmart, whose principal place of business is located in Arkansas. So it seems like, hey, Knickerbocker said they was in Arizona. Defendant like Walmart, like, no, we our principal place of business in Arkansas, which it is in Arkansas. Let's go down to count one here, or at least answer to one. Walmart lacks knowledge or information sufficient to confirm the truth of allegations in paragraph 1 in the complaint. So what is paragraph 1? Essentially, it's talking about the principal place of business. So we're actually going to go to the facts comment, the meat and potatoes of things. So to the right here, Walmart lacks knowledge or information sufficient to confirm the truth of the allegations in paragraph 4 of the complaint, and therefore they're denying the allegations. What's paragraph 4 of the complaint? Let's look to the left. That, hey, this almost is a shot. Knickerbocker saying this is the leading manufacturer of bed frames and bedding support systems and been operating for over 100 years. Man, Walmart like, yeah, we deny those allegations. And essentially, kind of backing up here, when you file an answer to a complaint, you pretty much have to admit that paragraph of the complaint. You have to deny it, or you have to say we lack knowledge or information sufficient to confirm the truth of the allegation. So that's essentially why Walmart is saying, and we don't know. But since we don't know, we're going to deny. So you have to admit it, you have to deny it, or you have to say we don't know. That's essentially the 3 options. So you're going to see a theme here as we look at each paragraph in the answer to Walmart. They're either going to deny it, or they're going to admit it, or they're going to say, hey, we lack information to actually confirm the truth of the allegations that Knickerbocker is saying in this complaint, and therefore we're going to deny it. So I do want to let you guys know that that's going to be a common theme that you will see as I go through the complaint here. So let's go to paragraph 5 here. Paragraph again, they're denying it again. What was paragraph 5 of the Knickerbocker complaint? Knickerbocker is saying that essentially they've been around since 1919, and that they've been operating with trundle beds, folding beds, platform beds, so forth and so on. Seems like Walmart is denying that. Paragraph 6. Walmart like, oh, we don't know if they didn't build up this goodwill, so we're gonna deny it. 7. They say Walmart again. They're denying the fact that that's how crazy this is. Plaintiff is telling you that we got a U.S. trademark registration. Walmart is like, we don't know about that. When y'all can actually look at that. Y'all can go to the test database and look at it. So that's interesting that they're denying that. Paragraph 8 again, just continue talking about the trademark. They're denying that. Paragraph 9 of Walmart's complaint here Walmart's answer on the right hand side. They're again denying it again. What's paragraph 9 in Knickerbocker's complaint? Essentially, they're saying that the bed frames and bedding support systems are promoted in some under the term Knickerbocker. They're pretty much going to deny all this stuff. So as you see here on the right, they're going to deny a lot of this stuff. What 10 seems like it's a different one. The allegations in paragraph 10 state conclusions of law to which no answer is required. So what is 10? As a result of his long-standing trademark and trade name has garnered substantial recognition. So they're saying, hey man, we don't even have to answer that. So they look like they at least admit paragraph 11. Walmart admits that Finger Lakes intellectual property is not a Walmart supplier. So as you may have recall, Knickerbocker is saying, hey, we didn't give Walmart essentially a license to be able to use our product. And Walmart is like, yeah, we admit that. We own Walmart is not a supplier of Knickerbocker. And then again, this is something interesting here in paragraph 12. Walmart admits that the URL includes the words Knickerbocker bed and frame. Walmart further admits that this web page, which is automatically updated over time, may sometimes list bed frames. Okay, look at Knickerbocker, like, okay, why does it have to list Knickerbocker bed frames? So Walmart further admits that as of the date of its answer, none of the product titles listed on the URL contain the term Knickerbocker. Walmart otherwise denies the allegations of paragraph 12. And you guys have to let me know in the chat section. I know with Amazon, and I don't kind of use these e-commerce platforms a lot for selling stuff, but I know obviously on Amazon you can sell your products, eBay you can sell your products. Does Amazon have a similar feature where if I want to sell my bed frame or whatever the case may be, I can actually go on Walmart.com and sell it, and somebody can buy it off Walmart.com? Obviously, I know you can do it on Amazon and you can do it on like eBay and so forth, but does Walmart have a similar feature, or are all the products listed on Walmart.com products that are actually sold by Walmart as opposed to a third party, which is using Walmart's platform to sell it? You guys have to let me know that. Okay, so Brandon, you saying that you can list your products, like if I wanted to sell something on Amazon, I can list it on Amazon instead of I can list it on Walmart instead of Amazon and sell it. Okay, that's interesting. So it seems like Walmart, their defense is going to be, okay, I got you. So again, I didn't know that. I don't use Walmart in that way, but it seems like Walmart is pretty much going to say, hey, somebody is listing their bed frame on Walmart.com, and we don't have anything to do with that. Okay, so Troy Sadler is saying third-party options as well. Okay, I didn't know that. So that actually changes things. So it seems like, if I had to guess, it seems like somebody listed their beds on Walmart.com for sale, and they're saying, hey, this is a Knickerbocker bed. So if that's the case, does Walmart, are they, the question becomes, is Walmart responsible for third parties listing other trademark terms on a bed for sale? I don't know. That's an interesting question, because I already know Walmart. I mean, Amazon, you do that all the time on Amazon. If I'm selling a name brand, I'm gonna put that name brand when I sell it on Amazon. And people obviously are not suing Amazon for trademark infringement for using those terms. So that I think that changes things. If a third party is using that term, I don't think Walmart would be on the hook for it, especially if they're scrubbing it. That's what Walmart is saying in their complaint. What is Brandon saying here? Yes, which would make this case stress. Yeah, I would probably agree with you. Again, especially, and I think that's what Walmart was saying in paragraph 12 here. It said, hey, Walmart further admits that this web page, which is automatically updated over time, may list some bed frames. I probably would have put some third-party bed frames. But it said Walmart is further admitting that as of the date of this answer, none of the product titles listed on its URL contain the term Knickerbocker. Walmart otherwise denies the allegations in paragraph 12. So Walmart is pretty much saying, look, some third party may have listed their bed on Walmart.com. They may have put you guys' trade name or trademark in the title or in the description of their bed, but we automatically over time scrub and take out these trademarks so that we're not on the hook. That's essentially what's going on. And as Brandon say, man, I've seen crazier things. So I'm not going to say it's trash, but I'm going to say it doesn't look good, which kind of almost begs the question. And you guys put it in the comment section. Why do you think Knickerbocker even brought this infringement case from the first place? Do you think Knickerbocker want to work with Walmart? Obviously, that's not going to help if you're going to sue the person that you want to work with, because that's not going to help the relationship. But it seems like, as an attorney, if you're coming to me and saying, I want to sue Walmart, and you give me these facts, do I say, let's file? I don't know. It seems like that's an uphill battle. But let's go back to the lawsuit here, or the answer, Walmart's answer, and continue to kind of mine it out. Something interesting may come up. So paragraph 13 here, Walmart states that as of the date of this answer, Walmart essentially the URL resolves to a web page showing a total of 8 pages of products and therefore denies allegations. So again, 13 here on the left, Knickerbocker is saying, hey, they have more than 25 web pages. And Walmart is saying as of the date of this answer, it's only a total of 8 web pages. And therefore they're denying what they're saying in paragraph 13. Paragraph 14 is saying that the complaint states conclusive loss, so they're not going to answer that one. Let's look at 15. This may be something interesting. Walmart's legal department admits that it received a letter from plaintiff's counsel in or around 2020. So this has been going on for a while. Man, that's been 3 years almost. And that Walmart's legal department directed plaintiff counsel to Walmart online IP reporting form available at brandportal.com. And again, this makes sense, man. A lot of times with these big companies, such as Walmart, such as Amazon, they can't just be taking these calls of everybody that's calling them saying that you're committing trademark infringement, you're committing patent infringement. So they have these systems and process online, these portals like Amazon. I know they have the I'm forgetting the name of it now. It'll come to me. Where if you have a patent, and I've kind of dealt with this with that system or portal, where if you have a patent dispute, you can submit it through that portal, and it's essentially kind of handle it as opposed to, and it can handle millions of these disputes as opposed to you having to call somebody up every time you have a dispute. I can't think of the Apex program. That's what it is. Amazon's Apex program. So this seems like it's essentially similar to Amazon's Apex program, but for IP, whether it's trademarks, copyrights, or patents. So it seems like they're denying everything else in paragraph 15, which is essentially talking about them calling the legal department. So 16, on information and belief that Knickerbocker Bed Company submitted a claim for Walmart. So they're saying, okay, they admit that Knickerbocker submitted a claim for relief on 2021. Paragraph 17 is saying that Walmart also admits that November of 2021, November 4th, a representative from the Trust and Safety informed Knickerbocker counsel that he had provided a search URL, not an item URL. So it seems like it was maybe some technical things, some technicalities at that point. Walmart investigation regarding the remaining allegations of 17 are otherwise ongoing, and because it currently lacks information, it denies them. So it seems like Walmart is saying in paragraph 17 that we're continuing to investigate what's going on as it relates to Knickerbocker and this trademark infringement, these products coming up with the term Knickerbocker on them. Let's go to 18. Seems like 18, they're saying that they're investigating. It's an ongoing investigation. Because it currently lacks knowledge or information sufficient to form a belief, they're going to deny it. But they're saying with respect to paragraph 18 of Knickerbocker's complaint, that investigation is ongoing. Let's look at paragraph 18 here to the left. Plaintiff explained in response that it used the term, it is the use of the Walmart search URL must cease. Okay, so essentially Knickerbocker is saying that Walmart needs to quit using a URL that contains the trademark term Knickerbocker in violation of U.S. law. So essentially, Walmart is saying that's ongoing. So let's go to paragraph 19. Walmart denies. So this is the first, just flat out denial. Walmart denies that any products were promoted under Knickerbocker bed frame. Walmart investigation regarding that, the remaining allegations in paragraph 19 is ongoing, and because it currently lacks knowledge or information sufficient to form a belief, they're denying them. So it's saying like, essentially they're saying that they're not promoting anything under 19, and then Walmart denies paragraph 20 here. Walmart denies characterization that was overwhelming evidence. So Knickerbocker has said something about it being overwhelming evidence. Walmart like, man, cut it out, man. Y'all hyping this situation up. Want no overwhelming evidence. So it said Walmart investigation regarding the remaining allegation in paragraph 20 is ongoing, and therefore they're denying them. And that's pretty much it. So, hey, what do you guys think? I think that this case is not really looking good for Knickerbocker, and that's why it's good to always look at these answers. Now, unfortunately, a lot of these cases don't get to the answer before both parties just get on the phone and get a settlement going. But that's why it's always good to look at the answer in these cases, because obviously the complaint is going to be drafted in favor of the plaintiff, but the answer is going to deny the answer that's provided by the defendant is going to pretty much tell their side of the story. And as we all know, that truth is in the middle. It's typically not with the defendant or the plaintiff. It's typically somewhere in the middle. And as we saw, it was looking bad for Walmart just looking at the complaint. But as we took a look at the answers, like, man, it sounds like somebody third party that had uploaded something with the trademark term in there, and seems like Walmart is scrubbing this stuff. But again, unfortunately, it takes time given their systems. And I guess here we are. It's crazy that it took 3 years. Let me know in the chat or in the comment section, what do you think was Knickerbocker? Because that's my $1 million question. Why would Knickerbocker do this? Because it seems like it's a pretty. Brandon called it. What Brandon say? He said it makes this case trash. I wouldn't say trash, wink, wink, but I do think it's a weak case at best. So you guys have to let me know in the comments or in the chat here, why do you think Knickerbocker brought this? Anyway, again, my big takeaway from this case is, hey, the fact that you had a company that has been going on for 4 generations, 105 years, hey, at least kudos to Knickerbocker for doing that. And like I said, they kind of built that up in part because of their IP. Obviously, we talked about this trademark infringement they didn't slap Walmart with, but they also have a number of patents as well. So they have a ton of IP associated with the company. And to the extent that they're been around for 100 plus years, they're doing something right. This case may not be looking good, but hopefully you guys got something out of this. Like I said, I thought this was different because it had an answer. So we'll see if Knickerbocker, I'm going to try to follow this one. And if Knickerbocker actually responds to the answer, because they can actually respond to the answer, to Walmart's answer. And if they do it, I may try to do a follow-up session to see where we're going, where we stand with these things. What Brandon says, they wanted the quick payout, but they playing with the big dogs. And that's my issue, Brandon. The big dogs is not going to give you a quick payout like that, especially if it's not. Again, I can see you having I mean, I guess sometimes you can't get the quick payout. Just, hey man, go away. But this company's been around for 100 years. You would think that this is not like somebody like a troll who's trying to get a quick payout, not really trying to run business. These guys been around for 100 years. So you would think that they're trying to actually run a business as opposed to trying to slap people with quick, slap big companies with trademark lawsuits or intellectual property infringement cases to try to get a quick payout. But yeah, it seems like Walmart kind of brought down that iron hammer or that iron fist and said, no, we're not going for it today. So, hey, that's interesting. I thought this was a good one, man. Let me know. Hopefully you guys got something out of this. We'll see what next week's lawsuit brings. Like I said, I was going to do the Playboy one. That boy had way too much nudity in it to bring to what I want to be a family friend show. So, till next time, gentlemen, ladies and gentlemen. Hopefully you guys got something out of it. Please subscribe to the channel if you haven't already. And go through and check out some of the video. Check out some of the interview, the other current events. I just dropped a Dame Dash video where, again, Dame Dash is talking about the whole reasonable doubt case and saying that it's not a copyright. You find, later on this month, his third of Rockefeller is going to be auctioned off for $1.2 million. And that's an interesting irony because a copyright infringement case against Dame Dash got him in a situation, but it seems like him having copyright, that being the Reasonable Doubt album by way of Rockefeller Records, his previously third share of Rockefeller Records, is going to get him out of his situation that he found himself in a hole with about $823,000 with the copyright infringement judgment that was awarded against him. So go check that out. Go check out all the other videos on the channel. Please hit the like button, hit the subscribe button. Trying to kind of create this IP community here. So hopefully you guys got something out of this, and I'll see you guys next week. Peace.